Mr. Chairman, sir, friends, it's a great pleasure to be here to share some of my thoughts on the challenging topic of taxation of charitable trusts as general public utility as explained by the Supreme Court judgment in the matter of Auda. If I were to explain the judgment of the Supreme Court in one word, I would say it is disastrous. It is disastrous for the SSEs in view of the effect it would create, the issues it will raise, and the problems that would be generated by virtue of operation of this judgment. I would make my presentation for about 45 minutes to 55 minutes, and then we'll spend some time in question answer. In the process, I will be discussing the issue in hand, but I would also be discussing at least two side issues which are answered by the Supreme Court by this judgment, which again have far-reaching effects and in a way unsettles the settled law. For want of time, I have not been able to prepare a PowerPoint presentation. But then what I would do is, what I have done is this. I have prepared one PowerPoint presentation, which effectively is nothing but the statutory provisions. It doesn't really add anything of value, not a word is added. Only Supreme Court judgment relevant paragraphs are being quoted over here so that you can examine them from proper perspective. Look at the section 2 clause 15 before amendment by the Finance Act 2009. Relief of the poor, education, medical relief are three specified categories. And there was the fourth category of advancement of any other object of general public utility. This did not really have any restriction in the matter of what kind of object and what kind of activity the trust would carry out, so long as it was a trust or an institution with the object of general public utility, it would be covered under clause 15 of section 2. We will go into historical background. I am just for the time being touching upon the statutory provision. Finance Act 2008 and thereafter by retrospective amendment of 2009, firstly a proviso is being added whereby in relation to the residuary category object of general public utility, now a restriction is being imposed and the whole discussion is going to be on this proviso. Provided that advancement of any other object of general public utility shall not be a charitable purpose if two conditions. It involves carrying out of any activity in the nature of trade, commerce, or business, or second prohibition, any activity of rendering any service in relation to trade, commerce, or business for a cess or fee or any other consideration irrespective of the nature of use or application or retention of the income from such activity. In other words, now there are two prohibitions, both operating independent of each other, whereby a charitable institution, which is an institution of general public utility, is involving itself in the matter of carrying on of trade, commerce, or business, or any activity of rendering any service in relation to trade, commerce, or business for a cess or fee or other consideration, it is disqualified from being treated as a charity. Question is, when do you treat activity of an institution in the nature of trade, commerce, or business or activity rendering any service in relation to trade, commerce, or business. We'll answer that and we'll see how Supreme Court has dealt with this issue. Later on, a proviso was added. We are not really concerned. A proviso was added with the last one, whereby up to rupees 10 lakh, if your receipts are in the nature of trade fees or consideration from business, you were still permitted to retain the status of charity. That 10 lakh was increased to rupees 25 lakh. And that 25 lakh was thereafter shifted from rupees 25 lakh to 20% of the receipts. So now the law as it stands today is, if you are rendering any services in the nature of trade, commerce, or business, or if you are rendering in service in relation to trade, commerce, or business for a cess or fee, you are ineligible for being treated as a charity unless the receipt from such prohibited category does not exceed 20%. Now with this, let's look at how the matter proceeded before the Supreme Court. Before the Supreme Court, essentially revenue was the appellant. The whole dispute started in relation to statutory corporations, urban development authorities, industrial development corporations, housing boards. They are all in receipt of huge sums of money. For example, urban development authority, when it is developing a particular area, it will acquire land, it will realign the land, it will redistribute the plot, it will sell the plot, generate money running into hundreds of crores of rupees. And those sums of money would be utilized for the purpose of developing that particular area. In other words, area development authority generates funds for the purpose of putting up schemes for the purpose of developing the area. Industrial development corporations, for example, will put up new industrial areas whereby a lot of facilities will have to be provided: road, electricity, sewerage, affluent discharge. All this would require huge funds. How would the Industrial Development Corporation raise funds? It will raise funds by allotting plots, by charging premium, by charging transfer fee. So there will be huge receipt of money, but the same amount was being utilized for the purpose of developing the industrial estates. Housing boards similarly. Now the target under the new law, unfortunately, was to begin with these statutory corporations. If you look at the judgment of the Supreme Court, which we are going to discuss, majority of the SSCs are statutory corporations. It is unfortunate because all these statutory corporations are effectively organs of the state, either central government or the state government. If you were to tax them, ultimately you are taxing the state from one arm of the government, from the state government, the money will go to the central government. In a way, therefore, it was a futile litigation, but it was for the revenue, for the income tax department, a cash cow. The amount which was likely to be realized would run into more than 100,000 crore of rupees. According to the statistics given during the hearing before the Supreme Court, it was reported. I do not believe it is correct because in that matter also I have appeared. The tax impact of only one SSC, MMRDA, with which all people from Bombay are familiar, was running into about 45,000 crore of rupees. Idea was to tax all those SSCs by claiming that what they are doing is a business. They are in the business of developing lands. They are in the business of selling lands. They are in the business of rendering services to business. And as a result of which, they will lose the status of charity. The other set of people who were before the Supreme Court, there were 6 set of people. The other set of people before the Supreme Court were statutory registering authorities or regulating agencies. For example, Institute of Chartered Accountants of India, where Institute of Chartered Accountants of India now collects huge amount from the students for the purpose of imparting education, for the purpose of conducting classes, for the purpose of educating them, so on and so forth. So the second target was these regulating agencies, Institute of Chartered Accountants or seed certificate agencies on the ground, you are actually carrying on business. The third set of people were trade promotion councils, export promotion council, which is in the business of providing facilities to the members to ensure that they are better placed in international market so that they are able to export their goods more easily. Ironically, this apparel promotion export council, which was an SSC before the Supreme Court, was an entity set up by Government of India. So the Government of India society sought to be taxed by Government of India and Income Tax Department, and the whole litigation went right up to Supreme Court. There were some non-statutory bodies which were also subject matter of litigation, like GS1, and a non-profit body again set up by Government of India, which is in the business of providing the barcoding to the products so that they can be exported abroad. There were cricket associations which were subject matter of dispute. There were some private trusts which were before the Supreme Court. So this was therefore a completely diverse group before the Supreme Court. Arguments also were advanced by diverse group from different perspectives. That was problem number 1. Problem number 2, before the Supreme Court, different assessment years were there. Some assesses were there for assessment in 9-10, some were 8-9, 9-10, 10-11, 11-12, 15. And as we have seen, every year the parameters have undergone little change. The Supreme Court was therefore called upon. Matter was argued at great length in February 2022. After detailed discussion a judgment running into more than 150 pages, the Supreme Court has, in a way, answered all possible issues. Has it answered or has it created more issues is something which we'll immediately see. But we will now proceed to examine what the Supreme Court has discussed at different paragraphs of the judgment, and then once discussion in relation to one issue is over, I will, from my perspective, for what I understand, the issues that are going to arise, I'll be putting forward. Therefore, I am now sharing with you only some paragraphs of the Supreme Court judgment, which are, as I said, reproduction of the Supreme Court judgment and nothing more than that. See, in paragraph 95 of the Supreme Court judgment, what happens is, if you look at the Supreme Court judgment, up to para 91, it deals with the arguments on both the sides. From para 92 onwards, the Honorable Supreme Court starts analyzing the law. In para 95, the Supreme Court says this. Okay, let me first go to, let me not take your time on this. Supreme Court traces the law. Supreme Court says, and in fact, tracing of law starts from a 1937 judgment of Privy Council. When the matter was being argued, I thought that the discussion will center around the 2008 amendment, nothing more, nothing less. I was completely wrong. The discussion started way back from 1922 law, 1937 judgment, 1939 judgment of Privy Council of Trustees of Tribune Trust, and the law which has developed over a period of more than 80 years was discussed. Supreme Court has, in the earlier part of the judgment, I am not for the time being going there, discussed that the law as discussed by the Supreme Court in the case of Surat Art Silk Mill was that so long as the object of the trust is predominantly charitable, and so long as activity is predominantly in the nature which is the charitable in nature, the fact that incidentally there is an income or surplus on account of some business which is being carried out by the SSE is not a factor which would destroy the SSE's case of a charitable institution. In other words, Supreme Court recognized that law till the amendment in question was implemented relied upon the predominant object. If the predominant object of the trust was to do charity, not to profiteer, to render services to the society, and in the process, incidentally, it also has a business, and that business renders income, so long as that income is being utilized for the purpose of development, for the purpose of object of that charitable trust, the SSE will not lose the status of a charitable institution. Therefore, the fundamental test was that of the predominant object. That was the principle laid down by the Supreme Court in the case of Surat Art Silk Mill, which was the judgment of the 5-bench judge of the Supreme Court Constitution Bench. One second. Okay. Please see the last 5 lines over here. However, the larger bench enunciated the principle of predominant object and held that what was of importance was whether the predominant object of the activity involved in carrying out of the object of the general public utility is to subserve the charitable purpose or to earn profit, and that such an entity would not lose its charitable character merely because some profit arose from the said activity, that activity being in the nature of trade, commerce, or business. The Supreme Court thereafter in paragraph 100 said that by virtue of the judgment of Surat Art Silk Mill, so long as dominant object was charitable and it did not essentially involve in business or commercial activity, generation of profit or surplus by it through activities incidental to that main or dominant object activity did not undermine the charitable purpose as long as the surplus or profit were used for the advancement of an object of general public utility. This is the principle which is accepted right up to the amendment in law. Having said this, the Supreme Court then starts looking into the amended law. The Supreme Court says, how do we look into or how do we interpret the amended law? It says, and correctly, that when a new piece of amendment is brought in, a new piece of legislation is brought in, you look at a historical background to see what were the problems for which the solution was sought to be brought about. So the Supreme Court looks into the historical background of the amendment. The Supreme Court then looks into the speeches in Parliament that could be regarded as a valid consideration for the purpose of looking into the reason for amendment. There is no issue over there. The Supreme Court then, and this is one fundamental problem which I believe is being created by this judgment, Supreme Court then considers the argument of the SSEs in the matter of interpretation of this amendment on the basis of circulars of the board. To recall, all of us are aware, when this amendment was brought in, CBDT issued 2 circulars. One, circular number 1 of 2008 of 19th December 2008, and another circular number 1 of 2009 of 27th March 2009. In both these circulars, the CBDT said that the amended provision would not be applied in cases of genuine charity. What is sought to be covered is those institutions which are wearing the mask of charity, but as a matter of fact are not carrying on charitable activity, and therefore the genuine charities need not really be apprehensive. Based on these board circulars, a strong argument was canvassed that we did not really travel into the larger areas of what is or what is not covered, because board itself accepts that if you are genuinely carrying out charitable activity, and so long as you are not masquerading yourself or wearing a mask of a charity when you are not a charity, you will not lose the status. So then came the question of what is the efficacy of circular of the board? Though all of us are aware that we have always been told that a CBDT circular binds the revenue, it's a one-way traffic, it binds the revenue but does not bind the SSC. Nobody would ever say it binds the courts. If the matter goes to the court, court will independently examine the provision. But then it was pointed out to the three-judge bench of this matter that Sir Navneet Lal Jhaveri's judgment of Supreme Court, which is the constitutional bench judgment, has clearly held that even if the circular is contrary to the statute, the same would bind the revenue. UCO Bank was also cited, which clearly stated that the question is not as to whether circular is valid or invalid. The question is if under the circular, a relief is sought to be given to an SSC, revenue cannot be heard to say that circular is wrong and don't give the relief. UCO Bank was followed by KP Varghese, Azadi Bachao Andolan, Vatika Township, again 5-judge judgment. Therefore, SSCs were banking on one strong pillar to advance their case, that interpret this provision from the prism of the board circular. And if under the board circular, the provision will have to be interpreted narrowly to cover only the cases of abuse, please hold, so long as there is no abuse, you will not deny the benefit of a charity. Therefore, statutory corporations or charitable trust or other institutions which are claiming to be charity, so long as they are doing activities which are permissible activities and they are not profiteering, please do not deny them the benefit of charity, because board itself in its circular has so held out. And here comes the first and disastrous problem. Supreme Court says board circular will not bind even the revenue. It's most unfortunate. It's most unfortunate because Navneet Lal Jhaveri's judgment is of a constitutional bench judgment. Now, this bench relies upon a judgment again of 5 edges in the case of Ratan Metal. Now, Ratan was a judgment under indirect tax laws. Language under the indirect tax laws is slightly different. And Ratan is in ignorance of Navneet Lal Jhaveri. And Navneet Lal Jhaveri, and after Ratan, we also have Vatika Township, again of a constitutional bench. Therefore, ordinarily we would have thought that the Supreme Court would hold that we will read down the amendment in light of the board circular. But please see what the Supreme Court has said in relation to board circular. Now, in para 123, the Supreme Court says, I have put on the screen, view exercised by Keshav Rijavji, IOC Ratan Metal. Though the last decision does not cite Navneet Lal Jhaveri, reflect the correct position. That is, that the circulars are binding upon departmental authorities if this is mighty, a multi-million ton, if they advanced a proposition within the framework of the statutory provision, or if they are contrary to plain words of a statute, they are not binding. Further, they cannot bind the court. Nobody disputes that, which have to independently interpret the statute in their own terms. At best, in such a task, they will be considered as departmental understanding on the subject and have limited persuasive value. At the highest, they are binding on tax administrators and authorities if they accord with and are not at odds with the statute, or at the worst, if they cut down the plain meaning of a statute or fly on the face of their express terms, they are to be ignored. So now, the argument which SSs were canvassing all along and brought successfully, that is, the board circular in my favor, I am entitled to relief, even though the circular may not necessarily be in tune with the letter or spirit of law, the whole set of judgment goes down the drain. So if now there is an issue, and this has nothing to do with section 215 or the controversy in hand, if there is a board circular in relation to some provision, SSA wants to rely on board circular, the revenue authorities, assessing officer will say, notwithstanding what the board might say, I believe that the circular is contrary to law and I will not go by the circular. It is therefore opening a Pandora's box of circulars now being required to be treated as valid if and only if they are in consonance with law. Now, if they are in consonance with law, why do you need circular? If they are to interpret the law exactly in terms of the language of the law, you don't really require circular. You require circular in the event of there being an ambiguity in the matter, and ambiguity is sought to be relieved in favor of SSC, or even if there is no ambiguity on account of harshness of a provision, the legislature feels or the board feels that some concession is required to be given. But the first side effect of this judgment is that circulars have now lost their efficacy. Somebody may have to argue that this judgment, to the extent it is contrary to constitutional bench judgment, is not valid, but then it's uphill task. Unless it is carried to Supreme Court and a larger bench, the SSs will have a problem. Having said this, let's see how the Supreme Court deals with this particular issue of the charitable trust or institution. The Supreme Court first looks into the question of trade, commerce, or business. The argument for the Supreme Court was that there cannot be trade, commerce, or business unless there is an element of profit. Argument on behalf of the revenue was something which you carry out consistently, regularly, for the purpose of attaining an objective is necessarily trade, commerce, or business. Income or profit is incidental in nature. This issue is being answered by the Supreme Court by holding that yes, there is a need to find that there is an object of making profit if you want to attribute to an activity characteristic of trade, commerce, or business. So an activity which is being carried out without there being any object of making any money will not fall in the category number 1. Then comes category number 2. Services in relation to trade, commerce, or business for fee, cess, or consideration. Let's see what Supreme Court has how the Supreme Court has dealt with this issue very briefly. I think every time I go off, it takes time. I think I will have to skip this. Permit to take off this. Okay. Supreme Court then starts dealing with the issue that in relation to services which are being rendered for fees or for consideration or for cess, there has to be again an element to make some money. And therefore, the court took a view that unless there is element to make money, unless there is an element or desire to make profit, the activity will not be regarded as that of trade, commerce, or business, or activity which is in the nature of services for fee or consideration or cess. In paragraph 143, Supreme Court expressly says that it is necessary that the activity must be motivated by profit. Similarly, in paragraph 144, it says that fees, cess, etc. must be something with a desire to make money. Having said this, where does the problem start? The problem starts because then the court starts explaining desire to make money or desire to have profit. Before the court, it was pointed out that in a large number of cases, the charitable trusts or institutions are rendering services or transferring goods. The argument was that what is being transferred is not with a desire to make profit, but with a desire to raise funds to feed the charity. Take an example of, let's say, an institution which serves the blind people. In order to make the physically challenged people economically independent, the institution runs a skill center where the persons who are placed there would, with the help of the skill developed by them, make, this is happening in Ahmedabad, I am sure it must be happening across the country, make furniture. Ahmedabad Blind Institute makes one of the finest quality furniture in Ahmedabad. That furniture is being sold. Question before the Supreme Court was whether the activity of selling this furniture would be regarded as in the nature of trade, commerce, or business or not. The argument of the SSs was, to be fair, this particular illustration was not that, I'm only saying generally. The argument of the SSs was that furniture is being made and sold so that if there is a surplus, that surplus would be used for the purpose of helping the institution so that it can serve physically challenged people in a better manner. If, let's say, a piece of furniture would otherwise fetch in the market rupees 20,000, of which cost is rupees 10,000, why should that institution sell that furniture at rupees 11,000 or 12,000 when it can fetch rupees 20,000, when the profit of rupees 10,000 would be used for the purpose of improving the lot of physically challenged people? The argument, therefore, was that so long as the dominant object or predominant object is not to make money, but to further the cause of charity, do not treat these activities in the nature of trade, commerce, or business. Supreme Court does not accept this argument. Supreme Court says, if the charity sells goods or renders services, it should do it at no profit or no loss, or with marginal profit. It says it is not possible to determine exactly what will be the cost. Therefore, to say it will be done at cost may not be possible. Maybe there may be some marginal profit. But if you are selling the goods or services at a price above the marginal cost, you are doing business. And if you are doing business, subject to that exception of 80-20, you will lose the benefit of a charity. This is, in my view, the fundamental problem. One problem of approach. Why should a charitable institution, which is capable of raising funds for the purpose of ensuring that funds are available for the benefit of the charity that it is carrying out, be told, don't raise the funds? Because if you raise funds, what you are doing is a business. Second, that's a problem on principle. But the second problem is more important. Supreme Court says, so long as you're recovering cost and marginal surplus, you are not doing business. But if you are recovering more than marginal profit, you are actually doing business. What is marginal? 5% is marginal, 10% is marginal, 15% is marginal. Take the very example that I took. Furniture cost is rupees 10,000. If I sell at 11,000, is it with marginal profit? Therefore, I am entitled to charity. But if it is at 15,000, it is at an exorbitant cost. And therefore, I will lose the benefit of charity. Supreme Court itself accepts that in a given case, cross-subsidization may be possible. For example, by dealing with the case of housing board, it was pointed out to the Supreme Court, housing boards have three kinds of, by and large, schemes: low housing, low income, middle income, and high income. Maybe middle income scheme, you sell the houses at cost plus marginal profit. But in relation to low income housing, because you are suffering losses, you will be transferring houses at a price far below the cost. In order to recoup that loss, you will sell the houses on high income group at a price above the actual cost. Would it mean that the houses that I have sold under the high income group is a business, whereas houses that I have sold under low income or middle income is not a business? I am required to sell houses at a profit because the profit that I generate would enable me to sell other houses at a loss. Do I take activity holistically of housing, or do I take activity segment-wise, low, middle, high, or area-wise, Andheri versus Bandra or whatever? How do you really look into this issue is the second problem. The third, which makes the whole thing completely unworkable. Please recall what I said. If you sell the goods or services above marginal surplus, marginal profit, it is business. Supreme Court says under section 11(4) capital A, then in relation to that business, you have to maintain separate books of account. Mark the words, separate books of account. I have, let's take case of that again, blind school. I have during the year sold furniture worth rupees 50 lakh. I believe that as a matter of fact, what I am doing is only recouping the cost plus little marginal surplus. And therefore, in any case, I am not in business. Assessing officer comes to a conclusion that in relation to some items, you have charged far more than the cost. There is going to be dispute as to how to work out the cost, direct cost, indirect cost, depreciation to be included, not included, keep apart all those issues. But let us say he comes to a conclusion in relation to some part of a receipt, there is an element of excessive profit, which would disentitle you to the benefit of charity. But I have maintained only one set of books of account. How do I have separate books of accounts in relation to what assessing officer believes is business versus non-business? If according to me, everything is non-business, in any case, I am required to have my books of accounts audited, which I have done. But I have not got a segregation of my business, segregation of accounts into two parts. One, what revenue believes is the non-business, and second, what revenue believes is business. Therefore, take a situation like this. In this example, my total turnover is 50 lakh or total sale is 50 lakh. AO comes to the conclusion that you have sold only one piece of furniture, let's say one table, at rupees 50,000 with excessive profit. Therefore, that 50,000 is a business income, far below the cap of 20%. But in relation to that rupees 50,000, because I have not maintained books of account, which is second cumulative condition which I am required to maintain, I would be told you will lose the benefit of charity. So now not only I need to be sure that everything and anything that I do will not fall in the definition of non-charity. If it falls in the definition of non-charity, that part of that non-charity should not exceed 20% is understandable. But question of maintaining books of account for that additional 20% is going to be completely disastrous, impossible. So if assessing officer wants to misuse or misread this judgment, I don't believe that court ever wanted to lay down this kind of law. But if assessing officer wants to misread a judgment, he will say, a part of your activity is in the nature of business, and in relation to that activity in the nature of business, trade or commerce, because you have not maintained separate books of account, you will not get the benefit of the exemption under section 250 completely. Now, Supreme Court has given 4 examples where Supreme Court says when it could be charity versus non-charity. Supreme Court says, take the case of a trust set up for the purpose of propagating the goal of Mahatma Gandhi. And if that particular entity, Peace Foundation, through various instruments, exhibitions, publishes the work of Mahatma Gandhi at low cost or marginal profit, that's permissible. But if that institution, and this is the example given by the Supreme Court, if that institution comes up with a coffee book on the life of Mahatma Gandhi and sells at high profit, it is not a charity. Now, therefore, the argument that you will have proceeds of charity of coffee book utilized for the purpose of the charity has gone. You must visualize when you are writing accounts that profit of that coffee book would not be a business, would not be non-charity, it will be business. You must have separate accounting in relation to coffee book transactions. And you must ensure that that coffee book transaction does not exceed 20%, failing which you lose the benefit of charity. The second example that it has taken is of low-cost hostel provided for the benefit of students. If it's a low-cost hostel for the benefit of students at cost or nominal markup, it is a charity. But if there is in that particular hostel rooms which are given with extra facilities at a surplus, it is not a charity. Where do you draw a line? Third example that the Supreme Court gave was marriage hall. If you are charitable institution running a marriage hall or owning a marriage hall, if you are giving it to the needy people at low rents, you are a charity. But if the very marriage hall is given with extra services at a far above cost plus nominal markup, you are not charity. Or if you're running a blood bank, that's a fourth example. But let me take 3-4 other issues. In Ahmedabad, we have one of the finest institutions for improvement of the lot of ladies. Elaben Bhatt passed away. You must have heard last week, Seva. Now, Seva ensures that skill is imparted to the ladies or women of the lowest strata of society so that they can come up with finest articles which would be sold. If Seva thereupon sells those articles, makes money so that women can be given better benefits, is it profiteering? According to Supreme Court, if there is more than a marginal profit, it is in the business. Coaching classes. Suppose in slum areas, in order to impart education to the children of needy people, somebody is running coaching classes and he charges nothing or he charges marginal amount, but in order to make good the deficiency, he runs another coaching class 2 kilometers away in a well-to-do locality, raises funds, surplus is used for the purpose of running the other coaching class, then the second coaching class is business. And if the surplus is or receipt is more than 20%, you lose the benefit of charity. But sir, how would he fund the first class if he's not raising money from the second class? That is not answered. So, okay, Gujarat High Court had given a beautiful judgment in the case of Sabarmati Gaushala Trust, where the argument of the revenue was that Gaushala, which was in the business of selling semen from the animals, from the cows, at a profit, was not entitled to the benefit of charity because it is selling at market rate. Gujarat High Court said, why should it not sell at market rate? So long as it is raising money which is being used for the purpose of charity, it is permitted to do so. Against this judgment, SLP was already dismissed. This was cited before the Supreme Court, but because it was SLP dismissed, probably Supreme Court does not examine this. Therefore, the issue that now comes up for our consideration is profit is completely to be ignored, is to be not to be earned by you, except to the extent of 20% of your receipts. If you are in receipt of a sum in excess of 20% from business, you go out. Not only if it is in 20%, this judgment proceeds on 80-20. But to recall, this judgment is in relation to AY 8-9 onwards. For earlier years, the ceiling was 10 lakh. For some years in between, ceiling was rupees 25 lakh, up to 10 lakh, then 12 to 15, 25 lakh. In all those cases, not 20%, but this 10 lakh or 25 lakh is the benchmark which you should not cross. If you cross that benchmark of 20 lakh, you automatically go out. Even if you do not cross it, or even if you are still in a position to solve the problem of charity versus non-charity, the maintenance of separate books of account issue is still an issue which I believe is going to create a very, very significant problem. Having dealt with the issues generally, now Supreme Court goes to the specific issues. I am going to the specific issues. I take about 10 minutes or 15 minutes because I need to discuss this in greater detail. Statutory corporations. The Supreme Court says so far as statutory corporations are concerned, and look at little unusual logic, though it is in favor of SSE, I would still say it's unusual logic. The argument of the revenue was that in their case, everything should be treated as business because they are receiving cess, they are receiving fees, they are receiving money from trade, business, commerce, they are selling plots. Supreme Court says in relation to these statutory corporations, we will not treat receipts in their case in the nature of business. Why? Because if we treat them as business, they'll cross 20% threshold. And if they cross 20% threshold, then they will be required to pay tax. And if they are required to pay tax, ultimately it will be tax on the public at large. And therefore, in their case, we will not treat it as a business receipt. Now, this is a very peculiar reasoning. If it is business, it is business. If it is not, it is not. But is it right to say that in case of this SSE, we apply different yardstick? Because if we apply the yardstick which we have placed otherwise for other SSEs to them, they will have to pay tax. So statutory corporations in a way went out of the net by virtue of this judgment because of, in a way, benevolent interpretation of Supreme Court in their cases. In their cases, Supreme Court said, if we are to apply the earlier logic, they would necessarily cross 20% threshold. So for them, these receipts are not to be treated as business. But, and there's again a big but if we find, or if assessing officer finds that these receipts are also in the nature of profiteering or generating profit, they would still be regarded for 20%. Now, what is profit? Profit is difference between consideration and cost. Now, take case of, let's say, housing development, not housing, Industrial Development Corporation or Area Development Authority. It reallocates plot, sales at a profit. Obviously, plot that it acquires is at a throwaway price or no price. For example, under the scheme of Gujarat Urban Development Act, AUDA acquires the plot of land. When the plots are realigned, 40% of land is acquired by AUDA free of cost. 25% used for general amenities like road, parks, hospitals, schools. 15% is sold away. Monies are made so that the schemes can be put up. Now that 15% which is taken by AUDA is practically at no cost. Whether sale of these lands, because it is at a significant consideration when it has not cost anything to AUDA, would it be profiteering? If you look at the earlier part of the judgment, answer is no. But again, Supreme Court has raised a flag over here and said, year after year, assessing officer will examine whether there is any element of profiteering or not. And again, that fundamental problem still survives. If assessing officer comes to a conclusion that part of your receipt is in the nature of profiteering and therefore business receipt, where is it that you have maintained separate books of account in relation to that part of business? And if you have not maintained, should you not be denied the benefit? This is the problem which I believe is going to arise. So in relation to statutory corporations, the court has been benevolent. Insofar as regulatory agencies are concerned, especially Institute of Chartered Accountants of India was before the Supreme Court. Supreme Court says good things about the institute, we should all be happy. It says that ultimately this is a regulatory body, but for the institute, the profession cannot be regulated, so far and so good. And therefore it is entitled to the benefit. If, however, and that is where the problem is, in para 197 it says, if, however, consideration is charged by the institute vastly or significantly higher than the cost, including admission to profession or towards examination, that would be regarded as in the nature of business receipt, therefore hit by 20%. Vastly or significantly higher than the cost. There is no arithmetical formula to find out what is vast or significant. There is no objective standards described by the Supreme Court. Therefore, I would not be surprised if assessing officer says that what would be the cost of form? Cost of form would be 15 rupees. Or maybe now if you are permitted to download, you have no cost of form except for device of form. Why should you be charging for the form? Admission to profession. Why should institute charge admission to profession? What is the cost involved? Cost will come only as and when the regulating that particular professional will start. Cost of education, examination. I have really no idea, but whatever it is. So again, in a way, a window is kept open. And all of us know experience of keeping the window open for the revenue. Ultimately, that window gets demolished, wall gets demolished, the structure gets demolished, SSE gets demolished. Therefore, now in relation to institute also, subject to this particular exception, benefit is given. Apparel Export Promotion Council, the body set up by central government, Supreme Court says that is a body which gives benefit to the industries. And because it gives benefit to industries, it will be denied the benefit of a charity. So far, I was not really worried. But I find observations by dealing with the case of Apparel Export Promotion Council, which must make all those who are sitting in this body worried. Why do I say so? It says if there is a body, trade associations, which renders services to its members so as to improve their skills by charging fees or consideration, then in that event, amount so charged would be regarded as in the nature of business. I am aware this program is free of cost, but BCA runs many programs at marginal cost plus a marginal revenue. Similarly, there are large number of other trade associations, commercial associations, bar associations, which render services to its members at cost, at marginal cost plus something, plus in a given case, sometimes it will higher cost so as to generate surplus to run the institution. Now, by virtue of clarification given in para 202 of the judgment, all these institutions will have to think twice in the matter of pricing of every program of theirs. If it is felt that pricing is so made so as to generate, in the language of Supreme Court, vastly or significantly higher than the cost, then you might be regarded as carrying on business. And if it is in excess of 20%, you will lose the benefit of charity. And even otherwise, you might lose the benefit of charity if you have not maintained separate books of account. Problem is, if you look at the board circular number 1 of 2008, it clearly stated that all trade associations need not worry about this provision because this provision will not hit them. I would therefore have otherwise said, okay, by virtue of board circular, I am protected. But we saw in the beginning, Supreme Court has said board circular, if it is contrary to law, is not valid. And therefore, if this board circular is contrary to Supreme Court judgment, it is not valid. So the trade associations cannot rely upon board circular. And if the trade association cannot rely on the board circular, and if this paragraph says that it is a business, again, you have a problem. Then comes three non-statutory bodies, ERNET and NICSI. Supreme Court says you are entitled to benefit because you are doing activity for the public at large. But when it came to GS1 India, which is a Government of India society, which is set up for the purpose of enabling barcoding on the product, which is a must for the purpose of export of goods. Supreme Court said, who gets the benefit of this barcoding? Business. Therefore, it is rendering services only to trade, business, or commerce. And therefore, GS1 is not entitled to benefit. Now, this is so far as Tribune Trust is lost because of 20%, so I will not go there. Before I close, there are two more issues. I said one thing about board circular, which is general in nature. There's one more thing which is general. Cricket associations partly lost before the High Court had succeeded. Supreme Court says High Court has not examined the issue correctly, matter is sent back. No issue over there. One of the arguments raised by the cricket associations was that sports is also an education. And if sports is an education, then we do not fall in the residuary category of general public utility. We must be given the benefit only under the main category of charity as education. The Supreme Court says what education connotes in the clause is the process of training and developing the knowledge, skill, and character of students by formal schooling. Please mark the words by formal schooling. Therefore, the term education would not include, not for the purpose of general public utility. Now I am the relief to the poor, education. Under that clause, education would not include any activity of imparting education unless it is in the matter of formal schooling. Institute of Chartered Accountant is therefore not imparting education. If you're running education classes for the purpose of training students for IAS, IPS exam, you are not conducting education. If you're running education classes for the purpose of training students in CA courses, if some trust is running, it is not education. Therefore, a very narrow meaning of the word education is given. It is true, there was the view taken in an earlier judgment, but then thereafter, it was possible to take a slightly different view, but Supreme Court reiterated, said they are not in the field of education. This is the second problem that we find is going to arise. In the end, Supreme Court says that 80-20 is a year-on-year exercise. Every year, SSA will have to show A, it is charitable in nature. B, it is not undertaking any activity of trade, business, or commerce, or is not in receipt of fee, cess, or consideration in relation to services in relation to trade, business, or commerce, or if it is rendering if it is doing business, trade, business, or commerce, or rendering services, it will not exceed 20% of gross receipt. That will be done on a year-to-year basis, and separate books of accounts would have to be maintained. Before I close, there is one more development, which is probably not as yet in the public domain because I had appeared in the matter. I am aware because Revenue moved an application for the purpose of clarification of this judgment. And Revenue said, you have laid down principles, but at the same time, you have dismissed appeals of the Revenue in case of statutory corporations. There is inconsistency between the two parts of the judgment, and therefore modify the judgment and permit us to redo every assessment. So a clarification application was moved. That clarification application came up for hearing before the Supreme Court last week. Just give me a second. I think I will like to share the judgment. 1 second. And Supreme Court has given some clarification, which is interesting. Just 1 minute. This is the judgment on clarification given by the Supreme Court. We'll ignore the earlier discussion. Please see para 5. Reference to application of the law declared by this court judgment, therefore, has to be understood in the context, which is that they apply for the assessment years in question, which were before this court and were decided. Who knows which are the assessment years? Nobody knows. I know for a fact because I was there for all the years. Otherwise, nowhere in the judgment it is specified which years are involved. Wherever the appeals were decided against the revenue, they are to be treated as final. However, the reference to future application has to be understood in this context, which is that for the assessment years, which this court was not called upon to decide, concerned authorities will apply the law declared in the judgment, having regard to the facts of each assessment year. In view of this discussion, no further clarification necessary. So the revenue authorities will apply this judgment with reference to assessment years for which court was not called upon to decide. I am still not very clear how this clarification will ultimately play out. In the result, to conclude, I have overstepped the time, but I thought it was necessary for me to explain broadly the issue. This is the judgment which has opened far more complex problems than anyone had ever thought of. When we went to argue the matter, we essentially thought the court is going to deal with statutory corporations and decide broadly on the point of whether or not they would be required to pay tax. In the process, few more SSs got added, and in the process, principles came to be laid down, which would have far-reaching effect in case of almost every SSC. Unless now, when this clarification application was being argued, Counsel for the Revenue said CBT is coming out with a circular clarifying the law as they have understood. Their understanding of law is always one-way understanding, and therefore now I expect a circular to come very soon, which will create, if hopefully will not create, but is likely to create far more problems. With this, let me thank you all for listening to me very patiently. And in spite of the fact that I did not run the PowerPoint, you patiently heard me. Thank you very much.
Thank you, Kishore. Saurabh. Can we take a few questions, Saurabh, if it's okay with you?
I have no problem.
Sure. Okay. Kinjal?
Yeah, I'll just share the screen.
Yeah.
So yes, I'll read out the questions. Charitable trust claiming deduction under Section 11, carrying on hospital and have substantial income from rental and interest on deposits. Any issue arises due to words solely or on account of Section 215?
No. So far as hospital is concerned, this judgment will not apply. This judgment applies only to the residuary category. It does not apply to the main, originally 3, thereafter 3 more have been added, but to the relief to poor, education and medical relief, this judgment has no application. So whatever happens will happen, but not on account of this judgment.
Okay. So second one is, I think the most common questions have collated all together. Trust having a community hall given on rent to general public, whether such activity is considered as business. If yes, whether it is to be treated as incidental to objects, and if no, whether such activity can be considered as a specific violation to Section 12 AB, explanation B.
See, the whole concept of incidental object versus principal object has now disappeared. Either it is permissible or it is impermissible. In relation to the actual example, Supreme Court itself has stated giving on rent a hall for marriage purposes at cost or with marginal profit is still permissible, and it will not be regarded as non-charitable in nature.
Okay. Now coming back to how do we look at a pharmacy run by a charitable trust for philanthropic purposes of providing medical facilities and research at cost plus basis on less than 20% profit plowed back to the objects of the trust?
No. Profit being plowed back again has now become completely irrelevant. Question is it medical relief? If it is found that it is doing services in the nature of medical relief, again this judgment will not apply. But let us assume it is not in the nature of medical relief. Then the question is cost plus. What is the plus that you are adding? Less than 20% of profit. I would not venture into what, according to the assessing officer, would be reasonable return. Would 20% be reasonable? If in the market, let us say there is a markup of 40%, then the markup of 20% is certainly a reasonable markup. But if in the market, the markup is 15% or 18% or even 20%, then it is certainly not a reasonable markup. It is a commercial rate.
Okay. In the blind school illustration, will this activity not be covered under education limb under section 215 and not covered under any other object of GPU?
If it is a formal education, yes, but if it is not a formal education, Supreme Court itself has said that formal schooling alone is covered by education, not otherwise.
Okay.
So blind school, if blind school is teaching the students in order to equip themselves for appearing in regular school or college classes, certainly it is education. But if it is, let's say, giving them vocational training, treating them good enough, ensuring that they acquire skill to be able to stand on their feet in the society, it may not be technically education.
So the next question is, do different profit centers or cost centers tantamount to separate books of account?
If you look at the judgment of Supreme Court to its logical end, yes.
Okay. I think this is more of a repetitive. What about religious trusts giving room for seva for 1 day or 2 days and taking donation from the yatri?
No. If it is again at cost or some amount above cost, there is no problem. But if you charge rupees 5,000 a day for giving a room, surely you are profiteering, or you are doing it on commercial principles.
This is more of an interpretational question. In a way, the Honorable Supreme Court is saying that advancement of general public utility means it should be for the benefit of public or society at large and not for the specific segment or strata of society for which the institution was established to serve, that the trust cannot generate a surplus or profit from even the society at large. Is this how the judgment has to be read now?
No, first sentence is not emanating from the judgment of Supreme Court. Trust can cater to a section of the society. This judgment nowhere says that it has to cater to the whole society and not a part of the society. So far as second part or the second sentence of this question is concerned, trust can generate surplus or profit. It will be regarded as in the nature of business income. So the moment you cross the threshold of 20%, you lose the benefit of a charity.
Okay.
And again, this business has to be incidental to your main activity. You are not permitted to carry out any business of your choice. If the trust is running, let's say, a dispensary, then running of a medical store may be permissible. But you just cannot open a medical store and start selling pharma products at commercial rate as business, because you want to generate profit there for the purpose of plowing with the profit and let's say feed another activity of a charitable trust, like helping students to pass out schools by giving education to them. Therefore, the two things are to be in relation to each other, not unconnected.
Okay, I think that answers the next question regarding running a hospital. Institutions holding workshop for public and collecting fees for parenting awareness or any such programs, will it be now considered as business activity?
If it is with a reasonable surplus, yes. If it is at cost plus marginal profit, no. Don't ask me what is marginal. I don't know.
That is a lot of questions asking what is marginal profit and how it will be.
I do not know. Even assessing officer would not know. So he will apply his standard. We'll have to go on defending ourselves.
Correct. So can the Supreme Court rely on ratio of Indian Chambers of Commerce case, which is specifically overruled in Surat itself, to come to a conclusion that the dominant object test as compared to incidental object test is misplaced and hence the exemption under section 11 cannot be granted?
Answer is no. But then, to be fair to Supreme Court, it has not relied upon Indian Chamber of Commerce judgment, because it is aware that later Supreme Court judgment of FICCI is in favor of SSC. What it has said is that now the law is amended by virtue of amendment of section 215 because of the insertion of proviso. If the law gets amended, obviously the judgment of the Supreme Court under the old law may not really be applicable. So I don't think they are wrong by saying that law, we will go back to Indian Chamber of Commerce, because they are not going to Indian Chamber of Commerce as the correct law. They are going to Indian Chamber of Commerce by saying what Indian Chamber of Commerce said is now being brought on the statute book by virtue of insertion of proviso.
So does this also impact NGOs acting as implementation agencies for corporates and assisting in CSR spending?
Yes, it will impact them.
Okay. So now this question, again, clubbing up of multiple questions with respect to Nobel Education Society case law. What is the impact?
No,
Yes.
I have really not examined that judgment, because after the judgment was pronounced, immediately thereafter I went abroad, and
Okay.
I would not be correct, but let me answer this very briefly. See, that judgment explains 1023C and essentially explains the word wholly or solely. Why should anyone go for 1023C now? Because 1023C is subject to the very prohibitions with which section 215 is governed. Now we would rather go by 215, and where I don't have to satisfy the criteria of solely. So if I am an educational institution, I would rather now go under 215 rather than go under 1023C, where I need to satisfy sole education purpose as the object. Whereas under 215, I don't have to show sole purpose, I have to show the sole activity.
Okay.
But subject to that, I have not studied this judgment in great detail. I had not argued the matter, and I frankly did not have time to go through and study the judgment in as much detail as I would wish I could have done.
Okay. So another question is that what about passive incomes like interest, dividend, shares held before threshold during the year?
I believe they would not be regarded as business income.
Okay. So a receipt by a school for any prospectus sales, registration, admission fees, or any other service for career guidance or miscellaneous services, whether it can be now considered as education, as there are a lot of expectations beyond the formal schooling.
Your mere expectation beyond formal schooling will not solve the problem, because Supreme Court says education means formal schooling, number one. Number two, while dealing with Institute of Chartered Accountants case, Supreme Court itself has stated, even in the matter of admission or conducting examination, you cannot profiteer. So this criteria will now become material criteria. To what extent it will hurt the SSC is something which will have to be seen in the case of, in the facts of each case.
Okay. So another is whether the judgment will be applicable to research organizations associated with educational organizations involving research and consultation both.
If consultation is being carried out or is being held on commercial principle, the 20% ratio will apply. Or if research is being sold at profit, which is more than marginal cost, marginal profit, again that principle will apply.
So yes, another question more practically, how does the Supreme Court decision impact a charitable trust which has been granted a provisional approval under Section 80G? However, the trust is primarily engaged in activity of organizing religious and cultural festivals, example Navratri Pujas, where the collections from stalls, banners, etc. exceed 20% of the threshold.
To my mind, it will be hit, because you are actually carrying out business for the purpose of raising the resources. Please see, the shift of the law is earlier, so long as the funds were utilized for the purpose of the charity, the mode of raising the fund was irrelevant. Now the mode of raising the fund becomes relevant, and where you have used it becomes irrelevant.
Correct. So a sequel to that question is that now that if suppose it gets hit, then should the trust withdraw itself from the ATG registration since it is under the provisional approval stage?
Ideally, yes.
Okay. Just a minute. So yes, more or less, there are some repetitive questions